Welcome to The Murder Book, a true crime podcast, where each week we will present notorious crimes, controversial cases, unsolved cases, missing persons, and serial killers. Details of the crime scenes, childhood of the murderer, and the life of the victims will be explored. Each episode is translated into Spanish. We have a new episode every Monday, and you can listen to it at Apple Podcasts, Spotify, iHeartRadio, Amazon Music, Google Podcasts, and other platforms you use to listen to your podcasts. Let's begin. Due to the graphic nature of this episode, listener discretion is advised. Extreme caution for children under 13. Welcome to The Murder Book. I'm your host, Kiara, and we will continue today with part 3 of the Marilyn Shepard case, in which we are taking a look at Dr. Sam Shepard's civil trial case. But before we begin, I want to do a shout out to Jamie. Thank you for your email and your feedback. It gives me a lot of food for thought to improve my show. So thank you very much. And also greetings to Germany, Philippines, Guyana, Trinidad, Tobago. Thank you for also listening my show. Let's begin. So now, with the conclusion of the opening statements, Prosecutor Bill Mason and his assistants felt confident that they have achieved a strategic advantage, while acknowledging that Terry Gilbert had made a well-organized presentation, stating his convictions with passion and sincerity. Prosecutor Mason believed that Gilbert had promised to deliver too much. Mason knew it was a tactical error for anyone to overstate a case in the opening statement. One thing is that jurors have good memories, and they would expect the Shepard team to substantiate all claims. Of course, Mason would remind the jurors of any unfulfilled promises made by the plaintiffs, knowing that an unfulfilled assertion or claim in a critical element of the case can undermine the integrity of the whole case. Gilbert had made a number of bold claims. He had condemned the behavior of law enforcement officials, legal officers, and the media, blaming them for a miscarriage of justice. He had misrepresented the marital relationship between Marilyn and Sam Shepard. He had promised that powerful new technology would prove Sam Shepard's innocent. And finally, Gilbert had promised to identify the real murderer. Based on the evidence and the testimony he had accumulated, Mason knew all of these assertions could be challenged and in some cases refuted. The Shepard team, the plaintiff, they would have the first opportunity to present its case. All of the experts and evidence heard and observed for the next few weeks will be orchestrated by Terry Gilbert. The only recourse that Prosecutor Mason and his team would have during this stage of the trial would be the cross-examination of the Shepard witnesses. The state's own experts and witnesses, armed with conflicted observations and interpretations, will have to wait until the Shepard team rested its case. The prosecutors would have to bide their time for what would seem like an eternity, all the while hoping that the jurors will recognize the only one side of the story was being presented. Reviewing the witness list, Mason saw that F. Lee Bailey, the nationally renowned lawyer who had won an acquittal for Sam Shepard in the 1966 trial, was the first witness. Although he was certainly an important witness, Mason suspected Bailey had been selected as the lead witness, and because of his importance to the plaintiff's case. Rather, he saw his presence as a means to generate national publicity and attention, another ploy by Terry Gilbert to influence public opinion. A number of reports and rumors about other efforts by Gilbert to manipulate public opinion were circulating during the early stages of the trial. For example, one story later reported and confirmed by investigative reporter and author James Neff was that Gilbert had contacted a number of high-profile Hollywood actors such as Harrison Ford and Denzel Washington, and offered to pay their way to Cleveland if they would be willing to visit Judge Suster's courtroom in a show of support for the cause of justice for the wrongfully imprisoned. Gilbert, according to Neff, hoped that these popular movie stars could generate sympathy, I should say, for the Shepard case among the news media and the jury. Amidst these rumors, Gilbert's daily recital of the injustices perpetrated by the legal system against his client continued. Despite his constant repeated blame of the media circus that he claimed had led to a wrongful conviction in 1954, he himself was now trying to promote this same kind of atmosphere around the present trial. Mason was angry that the Shepard team was doing everything it could to influence the jurors through public opinion rather than allowing the jury to go about the work in an unbiased manner. After the research that first afternoon, Judge Suster reconvened the jury, provided each member with notebooks so that they could take notes if they so desired on all of the testimony that would be presented over the next few months. The judge then directed Terry Gilbert to call his first witness, and Gilbert called out F. Lee Bailey to the stand. On cue, Bailey strode confidently into the courtroom. Observers wanted to catch a glimpse of this legal star and maybe get an autograph or shake his hand. And after he was sworn in, and he seated himself in the elevated witness box to the left of the courtroom, Bailey clearly was not the same man who had successfully represented Sam Shepard in 1966. As he noted in his opening pleasantries with Terry Gilbert, he had only been 33 years old when he defended Sam Shepard. He was impeccably attired in an expensive dark gray suit. But this Bailey had thinning gray hair. He had a slight tremble to his hands. And recent questionable ethical decisions involving his legal practice had tarnished his reputation in the legal profession, if not with the general public. Mason, observing the deference provided to this legal star, realized that on cross-examination, he would have to demystify Bailey's aura. The Sam Shepard case had been Bailey's first major trial and had provided him with national publicity and celebrity, which enabled him to secure a number of high-profile cases that built him a very lucrative practice and supported his extravagant lifestyle. Prosecutor Mason was sure Bailey would want to do everything possible to protect the reputation he had won in this famous case. In response to questions from Terry Gilbert about his background, Bailey talked about his experience as a lawyer, lecturer, writer, military pilot. Gilbert then asked if he was involved in any way with the Dr. Sam Shepard case. Bailey described how he first became aware of and involved in the defense of Sam Shepard in November 1961, 1 year after he had passed the bar exam. He spoke about how he had tried to arrange a polygraph test for for Dr. Shepard, who at the time was in prison in Marion, Ohio. He described how the Shepard family had hired Bill Veeck, a former owner of the Cleveland Indians and one of the all-time great promoters, to champion Sam's cause through any and every medium in which he could turn public opinion in favor of Sam Shepard. After public officials turned down his request for the polygraph, he filed a writ of habeas corpus alleging numerous constitutional violations that occur in Dr. Sam Shepard's original trial. In his testimony, Bailey criticized the conduct of the original trial judge. In support of his criticism, he recounted how he had heard a distinguished reporter say that before the trial even began, the judge had told her he was surprised that she was in Cleveland for a trial that was so routine, that it was an open and shut case, and the defendant was guilty as hell. He also said that the original trial was not conducted fairly, and that local newspapers had pressured the legal community to convict Dr. Sam Shepard. Bailey testified that his writ of habeas corpus led to Dr. Shepard being eventually released from prison. He said that the United States Supreme Court decided that the conduct of the press and trial judge was inappropriate. Gilbert then held up a binder and displayed to the jurors dozens of newspaper articles, which he said made a point about the Cleveland Press's negative onslaught against Dr. Shepard. Gilbert asked Bailey about the second trial. Bailey explained his preparation for the case, stated that the prosecution's admission that it never could find a surgical instrument similar to the one Coroner Gilbert claimed was the murder weapon, and the scientific evidence of Dr. Paul Kirk were key to his winning an acquittal for Dr. Sam Shepard. Bailey reiterated the familiar refrain that Kirk's scientific analysis excluded Sam Shepard as the murderer. Then, in a surprising, well-rehearsed, and what Mason felt was a misleading line of questioning, Gilbert said, quote, "Mr. Bailey, there have been a lot of talk about the affairs of Dr. Shepard. Did the prosecution in the second trial of Dr. Shepard bring up the extramarital affairs of Dr. Shepard?" And Bailey responded immediately, "No." And he added that Susan Hayes, which was Sam's mistress, was mentioned peripherally but never called as a witness, nor was her prior testimony offered. And then he said, quote, "She was not offered to the jury as a motive for the killing, and I don't think I heard it argued by either of the excellent lawyers for the state," end quote. So later, Bailey again described the prosecution's attorneys as good lawyers, and he said that they knew what they were doing. They were trying to make a silk purse out of a sow's ear. Mason knew that this tactic was intended to preempt or discredit the introduction of Sam Shepard's affairs as a motive into the current trial, making the jurors feel that this was something inappropriate. So, of course, it got him mad, infuriated him that Bailey would characterize the prosecution's case in such a disparaging manner. So now, the attorney, Gilbert, tried to follow up this testimony with an even more deceptive question when he asked, "Did the prosecution give you any indications why they decided in the re-prosecution to base their case solely on the evidence in the case and not on the extramarital affairs?" And Mason, at this point, he shouted objection, and it was sustained by Judge Suster. So Prosecutor Mason shook his head. He was disgusted because this was a blatant attempt to deceive the jurors. How could Gilbert suggest that Sam's extramarital affairs were not evidence? So now Gilbert switched focus, and he probed Bailey's theory of the murder. And Bailey said that, quote, "In Ohio, at least at that time, to prove someone guilty using circumstantial evidence, you had to exclude every reasonable hypothesis or theory of innocence," end quote. If one reasonable hypothesis that seemed plausible to the jury remained, that, according to Bailey, this is Bailey explaining, so that in itself was really an instruction to the jury to acquit, no matter what else they might have thought. So his position in the 1966 trial was to provide, in addition to the evidence that he brought in, a plausible theory of who had committed the murder, knowing that unless the jurors could rule this theory out, they would have no choice but to find Sam Shepard not guilty. So, Attorney Gilbert followed up by asking, did you explore a plausible alternative theory of how the crime was committed? And in an almost apologetic manner, Bailey said that he had to take the position that if Sam had not committed the murder, and that he was convinced that he had not, then someone else had to. Whenever one deals with a murder case, one has to look at sexual aspects of it before ruling them out, and that's what he did. So Bailey said, quote, we suggested that a neighbor was having an affair with Marilyn even at the moment when the blows started to hit her head. That the neighbor's wife caught him in the act and lost her head and beat Marilyn to death with a series of not very strong blows with a weapon very much like a flashlight, end quote. Mason wrote a series of notes to himself to use on cross-examination of Bailey, and he noted that Bailey did not tell the jurors that the neighbor he was referring to was Major Spencer Hook. It seemed totally implausible to Mason that Shepard, who supposedly suspected his wife was having an affair with Hook, would call Hook when he found Marilyn murdered. So Gilbert then changed topics again, and this time trying to convince the jurors there was a conspiracy to withhold evidence that would have proven Sam Shepard's innocence. F. Lee Bailey, in response to a series of questions, claimed to have never been informed of a flashlight and a t-shirt that was found in the lake close to the Shepard home, items that he claimed would have supported his case. He also said that the original defense team was not allowed to investigate the crime scene, which made it impossible to defend the case effectively. In closing, Gilbert gave Bailey the chance to describe his contacts with Shepard after Sam had been released from prison. And so he talked about an individual whose condition had deteriorated as a result of his harsh treatment by the state of Ohio. When Gilbert said he had no further questions, Judge Suster announced another break. So now Prosecutor Mason and his staff used this time to review the strategy for the cross-examination of Bailey. Bill wanted the jury to hear how speculative Bailey's theory of the murder was, how flimsy the set of facts on which it was based, how much conjecture was involved. They decided to try to force Bailey to explain what actually would have had to transpire for his theory to be correct. Mason was confident that the jury would see the absurdity of this scenario. So Prosecutor Deaver emphasized that it was also important to specify the role of Sam Shepard himself played in accusing Marilyn of having a number of affairs and in identifying the Hooks as her murderers. So Prosecutor Mason entrusted Steve Deaver with this important cross-examination. Under the direction of Terry Gilbert, F. Lee Bailey had depicted Sam Shepard as a wrongfully convicted man, the victim of an incompetent or corrupt law enforcement community, and of a news media that had created a public frenzy akin to a lynch mob. Deaver began his cross-examination with a brief review of the chronology of the case before focusing on the relationship between Shepard and Bailey. Bailey acknowledged that he spoke to Sam Shepard a number of times about the facts of the case and possible suspects and about his knowledge of the principals involved. Deaver asked Bailey about his investigation of the case and how he had identified the murderer of Marilyn. Bailey responded by indicating that he had read a book by Paul Holmes, a Chicago journalist who covered the Shepard case and whose book argued that Sam Shepard was innocent and suggested an alternative murderer. Consistent with this book, Bailey said, quote, "If you had to come up with a plausible alternative to Sam Shepard, the hooks, look pretty good." End quote. This response did not strike Prosecutor Mason as a particularly strong indictment of a murderous couple. So Deaver then showed Bailey a series of letters from or to Bailey in 1964 and in 1962 and 1964 that identify Eberling as a suspect and that offered the hooks as the better plausible alternatives. So as why the hooks were the better alternative, he said that this scenario was most consistent with the theory that two people had committed the murder. And he also said that in discussions he had with Sam Shepard in the early 1960s, the doctor had expressed the impression that he was pretty sure that he bumped into two people and that he knew who was involved. Seizing on this, Deaver asked Bailey why, if Sam thought that there were two people, he never mentioned it during his days of testimony in 1954. In fact, Deaver added, why was it that during the first trial, the whole version of the events put forth to the jury, it was a bushy-haired man? So Bailey seemed somewhat perplexed, and he said, quote, "That was the defense that William Corrigan put up for Sam Shepard, including Sam's version of the story. And Sam did not want to get committed, as I understand it, that there were being two figures there when his recollection wasn't that good," end quote. So then Deaver asked a question sarcastically. He said, "Yeah, yet years later, his recollection improves." So now Deaver referred Bailey to a letter dated August 19, 1964, that Bailey wrote to Sam Shepard asking him to submit to a hypno-interrogation. Deaver noted that in the letter, Bailey had written that the results of this test would be very confidential, and that, as you know, and this is quoting Bailey in the letter, "As you know, I'm personally satisfied that Esther Hook murdered Marilyn in the presence of Spencer. If the information derived from hypno-interrogation is sufficient to demonstrate this as fact, we will see that the blame is lifted from you and properly placed one way or another," end quote. So as Prosecutor Deaver read this paragraph, Mason hoped the jury understood that Bailey was telling Sam Shepard what he hoped they would uncover through hypnosis. Bailey, in defense of his letter, reiterated that the Hooks as murderers was part of the Holmes theory, beginning on page 303 of his book, and it went all the way to 313. And he said that he bought it initially, and it got stronger through the years, even until today. So Prosecutor Mason was happy to hear that Bailey constantly reaffirmed that he had developed his sophisticated theory of the identity of the murderer based on a book that was written by a reporter. Throughout the review and preparation for this trial, he and his team had been stunned that Bailey concocted such a lurid story from such a flimsy set of facts and conjectures. So Prosecutor Deaver's strategy was to use Gilbert's star witness to attack his revisionist theory of the identity of the murderer, a theory in which the Shepard estate had invested a great deal of time and public capital. He prodded Bailey. So he said, quote, "So you brought the Hook theory even after you evaluated Richard Eberling, the window washer, as the suspect who killed Marilyn Shepard," end quote. So Bailey replied with a very tone that you can tell he was indignant. He said, "I did not then or at any time since form a belief that Richard Eberlin killed Marilyn Shepard." Bingo. Prosecutor Deaver was ecstatic to have F. Lee Bailey, the supposed brilliant legal mastermind of Sam Shepard's second trial, so completely dismissing Eberlin as a viable murder suspect. With this statement, Judge Suster ended the proceedings for the day. On the morning of February 14th, the trial testimony began. The prosecutor set out to attack the Eberlin theory one last time before turning their attention to Dr. Sam Shepard's role in implicating his wife and neighbors. Greeting Bailey with a good morning, Deaver presented another letter regarding Bailey's investigation of Eberlin, saying not to beat a dead horse, but to finish up on the Eberlin issue as far as your preparation for the 1966 trial. Quote, he reminded Bailey that Richard Eberlin had actually been brought into the 1966 courtroom to testify on behalf of the Shepard defense. Bailey acknowledged that he did indeed call Eberlin. In a final effort to demonstrate the absurdity of the Eberlin as murderer theory, Deaver asked a series of rhetorical questions to which Bailey either nodded in the affirmative or say yes. Among these questions were, Eberlin walked past the defense table? Did Eberlin took the oath? Did Eberlin sat in the witness stand just a few feet from Sam Shepard? Dr. Sam Shepard watched Eberlin testify and during that time never said, "That's the guy." After all those years that he spent in jail thinking day in and day out about the horrible thing that happened on July 4th, 1954. So Bailey basically said a final yes at the end of the last barrage of factual questions. Satisfied that the Eberlin theory had been exploded, Deaver returned to the hook theory and the role of the accused murderer, Sam Shepard, played in promoting this interpretation. When Deaver asked who came up with the plausible theory that Marilyn Shepard was involved in an adulterous affair with Spencer Hook, Bailey replied somewhat evasively, quote, everybody knew that number one, she was clothed in such a way as to suggest at least foreplay, but no violence. That is that her pajama top was unbuttoned and her pajama button was off one leg. Neither garment was ripped. And number two, the testimony of the witness, Jack Krakauer from the Spank Bakery, who saw her giving a key to the house to Spencer Hook, telling him not to mention it to Sam, end quote. Deaver followed up with even a more precise question. He said, did Dr. Sam Shepard tell you that he believed his wife was unfaithful to him? And then the attorney Gilbert jumped up and objected to the question. Bailey answered simultaneously before the judge had a chance to rule. Bailey said, he talked about the possibility, yes. Gilbert asked the judge if he could approach the bench, where he argued vehemently that Bailey should not be able to answer those types of questions because they violated the attorney-client privilege and because they were based on hearsay. Clearly, Terry Gilbert did not want the jurors to hear that it was Sam Shepard himself who helped develop the theory that his wife was involved in an adulterous affair with his good friend and neighbor Spencer Hook. Deaver argued just as he vehemently that the jury must hear how Shepard's story changed over time and about the central role he played in implicating his wife and neighbors. In an effort to resolve the objection, Judge Suster dismissed the jury and witness and allowed the lawyers to argue procedural law. Finally, Judge Suster brought F. Lee Bailey back into the courtroom without the jury to answer questions as to whether Shepard waived the attorney-client privilege. Bailey stated that Sam Shepard repeatedly waived the attorney-client privilege. So he said, quote, there was no secrecy about any important fact in the case. end quote. During questioning before the judge about whether Sam Shepard had provided information about Marilyn having an adulterous relationship, Bailey answered that, quote, Sam had expressed the suspicion that she was involved with more than one man, end quote. After the jury returned, Prosecutor Deaver asked a number of questions that required Bailey to apply his theory. The most important questions included, Deaver asked, is it your belief that Spencer Hook came over and secretly entered the home of the Shepard sometime during the morning hours of July 4th, 1954? Bailey answered yes. Deaver asked, now, that was a holiday weekend, was it not? Bailey answered, it was. Deaver asked, Spencer Hook, on a Saturday night, decided to leave his home 3 doors down from the Shepards. Is that correct? Bailey said, yes. Deaver, the people who occupied the Hook home were Esther and Spencer, Esther's elderly mother, and the teenage children, correct? Bailey says, yes. Deaver asked, after Esther Hook went to bed, Spencer Hook got out of bed, decided to travel 3 doors down to the Shepard home. Bailey said he had what he thought was an invitation to be sure. So Prosecutor Deaver asked, what was it that he saw that he thought it was a special invitation? Bailey said, there was a room on the 2nd floor of the house. Sam frequently was called out in the middle of the night because he was the police surgeon and he had to do emergency medical work on people who were injured in various kinds of ways. So generally, when he got those calls, he would go to this room of the house and leave a light burning against his return. Deaver asked, so Hook enters into the home. If Dr. Sam Shepard is asleep on the day bed inside of the home on the 1st floor, Hook travels through the home through the kitchen area. Bailey said, bear in mind, Hook could not have seen Sam Shepard. So the prosecutor asked, why is that? And Bailey says, because it was under the staircase. Deaver said, what was under the staircase? Bailey said, the bed on which he was resting. So Deaver asked, you know that the staircase, there was an open banister, was it not? And that directly across from the bed was a fireplace with a glass mirror above the fireplace. Bailey said, I was there one time. I don't have a good recollection. So Deaver said he then proceeds to go up the staircase into the bedroom. And Bailey said, I would assume that's how he got there. So Prosecutor Deaver says, then he proceeded to engage in a consensual sexual act. Bailey says, well, one of them unbuttoned her pajama top and took her pajama buttons off one leg. I don't know whether that was an affectionate act on his part or an invited act on hers. So Deaver said, at the time Spencer Hook entered into the bedroom, did Spencer Hook close the door to consummate the sexual relationship he had with Marilyn? Bailey said the evidence would indicate he did not. So Prosecutor Deaver says, wouldn't it stand to reason the door would be closed? Bailey says, I think it would be prudent. So Deaver says, now, Esther Hook pursued Spencer Hook over to the house? Bailey says, yes. Deaver says, eventually Esther Hook makes her way up into that bedroom. Bailey's answer, yes. Deaver says, and then she finds her husband and Marilyn Shepard involved in a sexual act. Bailey says, either that or preparing to in all probability. Certainly, Marilyn was in a condition where a sexual act was contemplated. So Deaver says, you say Esther Hook came into the room, found Spencer and Marilyn Shepard involved in a sexual act, and she became into a fit of rage? And Bailey said, it would appear that a young man without much strength or female arrived at the scene and experienced displeasure and began to beat on Marilyn Shepard with some kind of weapon, and did so repeatedly to the extent that one would have to conclude that there was an aura of frenzy in the atmosphere. Prosecutor Deaver says, in developing the plausible theory of innocence, did you contemplate or ask the question of yourself, if Esther Hook did this to Marilyn, what did she do to her husband Spencer for messing around? Bailey said she put him in a position of misery for the rest of his life. Deaver asked, so after the assault takes place, Spencer Hook stands by and watches his wife pummel Marilyn Shepard more than 25 times? Bailey said, no, that's not correct. One must assume she was only struck once or twice before she yelled. The yell had that brought Sam up the stairs, so he didn't stand idly by which she swung the weapon 25 times. He had his hands full with a very able, strong, and virile 31-year-old. So Prosecutor Deaver says, so what are you telling us is that once Marilyn screamed, Spencer Hook was concerned about this person that he thought wasn't even in the home, first of all, because he had no idea Dr. Sam Shepard was asleep downstairs. He immediately retreats out of the room and lies in wait for Dr. Sam to come upstairs to save his wife. So, seeming that his esteemed witness was losing this battle of wits, the attorney Gilbert jumped up and objected to the questioning of Bailey. While the judge held a sidebar, Bailey collected his thoughts, and finally Deaver was allowed to proceed. And so Deaver says, so according to this plausible theory of innocence, Sam Shepard comes up the staircase, observes a form in the room standing at the foot of the bed, that being Esther Hook, and is clobbered from behind. So Bailey said, well, the two major injuries probably happened first, the neck and the teeth. There's no way to really make sure of that. It's entirely possible that Spencer clobbered him with the fist and broke the teeth, and as Sam fell back and turned, hit him in the back of the head and fractured his third cervical vertebrae. So Deaver asked, so Esther Hook escapes from the home, and it's Spencer Hook who goes through the stages of staging a crime scene. So Bailey answers, which is he doing when Sam regains consciousness? Yes. And Deaver asks, then we go downstairs into the den, which is known as the doctor's office. Found inside the doctor's office, you would describe it to be a simulated burglary. Nothing essentially of value was taken from the room. And Bailey says, well, no one could ever delineate any item of value that was missing that morning that had been present the day before. Deaver asks, so he had in that particular crime scene or in that particular home that morning a staged theft offense? And Bailey said, you can call it that, a very poorly staged cover-up. So Prosecutor Deaver then noted that Bailey, using his theory, was able to win an acquittal, and that in an interview with Time magazine of December 9th, 1966, he was quoted as saying, we had to destroy Marilyn. And so he asked him, do you remember making that statement? You were accurately quoted by the Time article. And Bailey responded, oh, yes. And Prosecutor Deaver said, well, and it was the decision that you made based upon consulting with your client concerning this information he had held back in the first trial. Is that correct? And Bailey said, yes. The last part of the cross-examination challenged Bailey's characterizations of the facts and evidence. He questioned Bailey's recollection of witnesses to Marilyn's infidelity, establishing that no independent witness had observed Marilyn being fondled. Regarding the t-shirt that was found on the beach, Deaver got Bailey to admit that it had not been a recent revelation to him, that in fact it had even been reported on the front page of the July 14th, 1954 Cleveland Press. Bailey argued that although he did know about it, he never got the actual t-shirt. So Deaver also pointed out that the flashlight that Bailey referred to was actually found 1 year and a month after the murder. Turning his questioning to the matter of the press, Deaver noted that there were 3 Cleveland newspapers in 1954, and contrary to the plaintiff's claims, a number of objective and supportive articles were written by these papers. He also asked Bailey about the relationship between Marilyn and Sam. Bailey claimed that calling the marriage trouble was an exaggeration. He said he thought Sam was telling the truth when he said that Susan Hayes and a few others were one-night stands, maybe 2 nights. Gilbert objected to a number of questions about the extramarital affairs of Sam Shepard that would have established the length of these relationships, and to the surprise and dismay of Deaver, Judge Suster sustained all of these objections. When Bailey was dismissed, he was besieged by a crowd of observers. Some were even asking autographs and autographed copies of his book. So immediately following the conclusion of Flea Bailey's testimony, the attorney, Terry Gilbert, called a pair of witnesses. He called Richard Nitter and Billie Jean Nitter. Mr. Nitter was a 73-year-old retired Ford Motor worker, testified that on the night of July 3rd, 1954, he and his wife had tickets to the Palace Theater to see Gone with the Wind. They left the theater at about 1:30 in the morning, went to a restaurant in Rocky River, where they dined until about 3 a.m. Then they drove along Lake Road through Bay Village, where they saw a man who was about 5'8" to 5'9", and about 160 to 170 pounds. Both witnesses indicated that the man looked weird and suspicious, and when they found out about the murder of Marilyn the next day, they thought the man might have had something to do with it. Marilyn Barclay Cassidy conducted the cross-examination of these witnesses. The prosecutors, based on their belief that this testimony was not very significant, did not attack the Nitter's story too vigorously. Cassidy had them acknowledge that they did not observe the man carrying anything or see any dirt or blood on his clothes. She also asked why they waited 10 days to report this sighting if they thought it was so important, and whether it was a coincidence that they reported it the day the Shepherds announced a reward for information. The Nitters denied that they were motivated by money and said their call to the police just happened to coincide with the announcement of a reward. At the completion of the Nitters' testimony, Judge Suster excused the jurors for the day with the usual admonishments. Mason was emotionally exhausted. He knew that Flea Bailey's testimony was important and was satisfied that the cross-examination had exposed a number of glaring inconsistencies in his trial theory, and he was confident the jurors saw that Bailey's interpretations were not the product of legal genius or inspired revelations. The Bailey mystique, he felt, had been effectively debunked. We'll be right back. The Shepard team began the trial proceedings on the morning of February 16 with the videotape testimony of Mildred Adler. She was not able to attend the trial. And Mildred was the wife of Dr. Leonard Adler, who was a physician employed at Bayview Hospital during the 1950s. And during this time, she had become friends with Marilyn and Sam Shepard. The attorney Gilbert presented this witness to attest to the health and strength of the Shepard's marriage. Gilbert asked, "Did you have occasion to see Sam and Marilyn Shepard together in the weeks and months before the murder?" Mrs. Adler responded, "Oh, yes." Gilbert then added, "How did they seem to you as a couple?" And she said they seemed to be good friends. So Gilbert continued and says, "Any tension between the two?" She said no. And after establishing the origins of her friendship with the Shepards, Attorney Gilbert asked her if she ever had an occasion to talk to Sam about his conduct with another woman. And Mrs. Adler said, quote, "The only other woman would have been Susan Hayes. There was a Halloween party, which would have been in the fall of 1953. It was held at the hospital in one of the large rooms. All of the interns and residents were there, and Sam danced with Sue much of the time. Marilyn and I were sitting together out in the yard under the trees, the yard of the hospital, Bayview." End quote. So Attorney Gilbert inquired whether she had had a conversation with Marilyn about this, and Mrs. Adler nodded her head and said how Marilyn had said, "There goes the playboy of the Western world." And Gilbert then discussed Sam, who Mrs. Adler said was warm, a wonderful athlete, a good physician. Attorney Gilbert asked Mrs. Adler about her phone conversation with Marilyn on July 3rd, 1954, during which Marilyn revealed that she was pregnant and expressed how fearful she had been out now that she was happy. Marilyn also indicated that Sam was thrilled. In the videotape cross-examination of Mrs. Adler, Prosecutor Mason concentrated on the relationship between Sam Shepard and Susan Hayes. She spoke again about the Halloween party, how Sam and Susan danced together the whole night. She also related how she had told Sam that she thought his behavior was very hurtful to Marilyn and that Marilyn had become her date. The afternoon session featured Dorothy Shepard, the 81-year-old wife of Sam's brother, Richard, who died in 1980. On direct examination, Mrs. Shepard described the Shepard brothers, their parents, their wives, and their homes. She said that she and Marilyn and Sam were an athletic, normal family and that Sam was thrilled with the recently announced pregnancy. She then recounted the events of July 4th and thereafter. She and her husband were awakened by a phone call from Spencer Hook at 5:30 a.m., who told Richard that something terrible had happened to Marilyn and that he should come to their home. Richard told her to call Dad Shepard and his brother Stephen, which she did. She then drove to get Mom Shepard and brought her back to her home at about the same time that Richard brought young Chip. At about 10:30 a.m., she went to Sam and Marilyn's house to get clothes for Chip and to remove the food for the party that Marilyn and Sam were to have hosted that afternoon. People were all over the property, although there were not many inside the house. She said that later that day she visited Sam at the Bayview Hospital and recalled that he looked like he was in pain and had a neck brace and swollen areas on his face. On cross-examination by Mason, Mrs. Shepard insisted that she had not talked to Marilyn about marital difficulties or the issue of divorce, but when faced with her testimony from 1954 inquest, in which she had acknowledged these types of conversations with Marilyn, she admitted it must have happened, but said she couldn't remember the conversations. But she also admitted that Sam's father would have not condoned a divorce. Attorney Gilbert, after soliciting testimony from Mrs. Adler and Dorothy Shepard to establish that Marilyn and Sam had enjoyed a normal, loving relationship, he called Fred Drecken to the stand. Drecken had been the first police officer to arrive at the scene. Clearly, Drecken, after his investigation, had suspected that Sam Shepard had murdered his wife, so Prosecutor Mason braced for a vigorous attack on the professionalism of the crime scene investigation. Consistent with the infamous O.J. Simpson defense, after which Gilbert had modeled his presentation, Mason expected to hear the terms contamination, unsecure crime scene, a great deal over the next few days. Early on in the direct by Attorney Gilbert, Officer Fred Draken established himself as a thoughtful, articulate, pleasant, sincere, and honest individual, making Attorney Gilbert's attacks on his competence and derision seem shrill, even misguided. In response to a question about his employment, Draken detailed his long time service to the Bay Village Police Department, where he started in July 1948 as a deputy patrolman and rose through the ranks to become chief of police before he left the department in 1976. He described the Bay Village Police Department as small, employing 7 full-time officers and 5 deputy officers in 1954. Gilbert asked Draken whether prior to July 3rd, 1954, he had, quote, had any training in crime scene investigation, quote. The officer said yes. In the fall of 1953, quote, I attended a school at the Law and Medical Center of Case Western Reserve University, and it was called Scientific Proof and Criminal Cases, end quote. This course was taught by Oliver Schroeder, the head of the law school, Samuel Gilbert, the coroner, and a few others. Gilbert asked about the events of July 3rd and 4th, 1954. So he asked him, did there come a time when you received a call concerning a matter at the Shepherd home? Draken says, on the morning of July 4th, yes, at a few minutes to 6 a.m. He explained how the mayor had called and told him to get over here right away. Something terrible had happened to Marilyn. He said that he went directly to the Shepherd home and entered through the front door. He described seeing an overturned medical bag and Dr. Sam Shepherd sitting in a red chair in the den. Then, without hesitation or any visible discomfort, Draken accepted Gilbert's invitation to demonstrate his actions at the scene. Using the model of the home and the floor plan projected on the screen, he pointed to and described various areas of the home. He then explained that he walked through the kitchen, up the steps into the rear bedroom on the second floor. There, he described seeing Marilyn lying in drying blood on the bed about 3/4 of the way down, blood covering her face and her legs protruding from under the crossbar at the bottom of the bed. Believing she was dead, he returned downstairs, left the home, went outside to his car, and called the fire station for help. He also instructed all of the members of the police department to pick up any hitchhikers on the road. During this portion of the testimony, Attorney Gilbert looked for any opportunity to criticize Draken's actions. Listening to Draken's recollection, he asked, when you arrived, you knew there was something awful that was happening at the Shepherd's home. Is that right? Draken said, yes. Gilbert said, you were the first officer to arrive at the crime scene. You saw that you had a homicide on your hands, that you left the crime scene unattended for some period of time. Is that right? And Fred says yes to those questions, seemingly oblivious that the fact that Attorney Gilbert was attempting to impart his professional competence. In a sincere tone of voice, Draken explained that it was, quote, to go out into the driveway to make this radio call for our doctor and for any additional help we could get, end quote. So Attorney Gilbert kept up the pressure. He said during the 2 to 3 minutes Draken was outside, Mr. and Mrs. Hook were in the house, and could he say what, if anything, anyone did while he was outside? So Draken said, no, if I'm not there, I don't know. So calmly, Draken continued his recollections. After Draken had called the fire station, Dr. Richard Stepper drove up. Draken took him to the crime scene to attend to Marilyn. Gilbert, sensing another egregious breach of protocol, asked, where was Mrs. and Mr. Hook? Draken, shaking his head, trying to recall, answered sincerely. He said, Mrs. Hook was there someplace. She could have been in the kitchen. And Gilbert said, "You have been a police officer for a number of years. You know a little bit about controlling the crime scene. Isn't it important to make sure that any non-authorized personnel be either secured or observed so that the crime scene cannot be contaminated? Isn't that an important consideration?" Drinkin answered yes, without hesitation. So then the attorney Gilbert continued. He says, "So you can tell us where Mr. and Mrs. Hook were at the time that you came back to the house after you made the call in your cruiser, can you?" And in a patient and logical manner, Drinkin said, "It wasn't my concern. My concern was that what we could do for Marilyn." So Gilbert, rattled by the obvious sincerity of the witness, and found himself responding, "I understand." Then he asked, "How long were you up in the room before you returned downstairs?" And Drinkin said, 2 minutes. And then he told Gilbert what he did and saw when he backed downstairs. And he spoke to Dr. Sam, who was wearing damp khaki pants and boat shoes, but no shirt, and had swelling over his left eye and mouth. He then he told Drinkin in halting statements, "I heard Marilyn scream, fighting on the stairs, and I was on the beach." And Gilbert asked, "Was anyone else in the room with you when you had this conversation?" And he said, "I think Spen Hook was there, and he may have been on the phone or something." So, sensing another opportunity to highlight the incompetence of the police, Gilbert says, he asks sarcastically, he said, "Was it common back in the 50s to let people use the telephone at murder scenes?" And Officer Drinkin appeared to consider this question carefully, smiled, and responded, "Well, no, but this was the mayor. He's our safety director." So Gilbert, caught off guard by this answer, asked, "Isn't it a good idea to make sure that no items or fixtures or objects in a murder scene are touched by anyone?" Drinkin paused, and again he said, "It's hard to answer yes or no. The whole focus of that was that we had a problem with the victim. I wasn't really beginning to focus on were we really following all the rules and procedures." So Gilbert, frustrated by these answers, interrupted and asked in a haughty tone, "Well, those rules and procedures, Mr. Drinkin, are designed, are they not? And you have been an officer for many years, that the idea is to preserve, maintain, and protect the crime scene." And Officer Drinkin enthusiastically agreed. He said, "Yeah, that's right." Officer Drinkin's straightforward, honest, expanded explanations for his behavior were not helping the attorney Gilbert promote his theory of contamination and incompetence. In this situation, because this was Gilbert's own witness, he could not, according to rules of procedure, limit the officer's responses and commentary as he would if this were a cross-examination of a hostile witness. The few times when Gilbert tried to limit Officer Drinkin's answers, Prosecutor Mason objected, and Judge Suster then instructed Gilbert to let the witness answer. Prosecutor Mason enjoyed watching Gilbert squirm in his attempts to discredit this police officer. None of his criticisms were compelling, and they did not seem to undermine Officer Drinkin's credibility or disturb his composure or captivate the jurors. So Attorney Gilbert persisted in what at this point seemed like a losing game. He even apologized while asking his questions. He said, you would agree with me, and I understand that you were doing the best you can under the circumstances, that the crime scene was not secure for at least 20 minutes while you were there. And there was this pause, long pause, as Drenkin pondered the question, and he said, well, I don't know what you mean by secured. I do know that by the time I had gone down to check the beach and came upstairs and ran up and told them, just leave her where she is, I mean, you are one guy. And Gilbert said, I'm not being critical of you personally, okay? I'm just asking you that for the 20 minutes you were there, and I know you were the only one there. You had a lot of things on your mind, and you had a lot of things to do. Can you say to this jury that the crime scene was secured when people were able to roam around that house at will for 20 minutes before you left that house and went out to the beach? And Gilbert asked the question because he was sure that the officer Dreckham would have to concede a dereliction of duty. And he wanted to play this up to the jurors. But Officer Drenkin, making eye contact with the jurors, responded in a way that was unanticipated. He said, I would say the counselor is right. Anything could have happened when you're not there. There was only myself, the mayor, who was the safety director, and his wife. My main concern was to do something for Marilyn and to see if anybody was in the area. I would say to you, the jury, and he pointed to the jury, you have to make a judgment. His demeanor and candor seemed to endear him to the jurors. And the attorney Gilbert's hard-edged sarcasm and accusatory tone and style seemed to succeed only in making Officer Dreckham a more sympathetic figure. So changing tactics, Gilbert asked Officer Dreckham to describe the condition inside the house that morning. Drenkin related his observations of a medical bag in the hallway that had been overturned, a desk in the den with its drawers removed and neatly stacked on top of one another, and a broken trophy. Gilbert then directed him to go back to 6:20 a.m. on July 4th and talk about his observations of the beach. He recalled that it was light outside. He descended the stairs to the deck, which extended about 10 feet over the beach. He looked in both directions and he didn't see any signs of struggle. Gilbert resumed his attempt to challenge Officer Dreckham's crime scene methods, asking him, how long did it take you to go down those steps, go down to the beach, and return to the house? And he said 4 or 5 minutes. And the attorney said, well, that would be another 4 or 5 minutes that a homicide crime scene was left unattended. Is that correct? And Drecken reminded the attorney, he said, well, there were people there. The mayor, Sam, and Gilbert asked when the first pictures of the crime scene were taken. Officer Drecken recalled that he took pictures at about 8 a.m. Based on this response, then, the attorney emphasized that until that point, he could not tell the jury whether anything in that house was moved, changed, turned around, or altered, correct? And Officer Drenkin listened intently, and then he said, yeah, I can. I made a quick perusal of the house. So Gilbert, at this point, he was frustrated by this pattern of response. So he asked Officer Drenkin to recount his actions after he viewed the beach. Officer Drenkin recalled going back up the stairs, noticing water spots and small puddles of water on the stairs and the porch. He re-entered the house and found that the Bay Village Chief of Police and members of the fire service were now at the scene. After conferring with Chief John Eaton, he called the county coroner and the Cleveland police to solicit assistance with crime scene testing. In response to a question from Gilbert, he said that the coroner arrived at about 8 a.m. Gilbert displayed some photographs of the house and murder room, asking Officer Drecken to authenticate them as accurate representations of the scene that day. And he also asked Officer Drecken to review and validate the statements of key witnesses that were taken by the Bay Village police officers. At the conclusion of Officer Drecken's direct examination, Prosecutor Mason felt that Gilbert had not successfully made the police investigation appear shoddy or unprofessional. Although the police present that morning were unable to ensure the integrity of every element of the crime scene, they had obviously been conscientious and professional. As Officer Drecken had repeated a number of times, they did the best they could given the circumstances. Believing that Officer Drecken had withstood Gilbert's attacks, Mason decided that he would highlight some important observations. Drecken had made and addressed a few issues that Attorney Gilbert had purposely avoided. He also knew that he was going to recall Fred Drecken as a witness for the state. Under Mason's skillful questioning, Officer Drecken described in more detail seeing a neatly folded brown jacket on the daybed, not detecting any footprints or signs of struggle on the beach, and noticing that the desk drawers had been neatly stacked on one another. He also revealed that he and a Cleveland police officer had checked every door and window and had found no sign of forced entry. The Bay Village police, he said, had investigated other suspects, gathering enough information on this case to fill 6 large binders. Drecken was dismissed pending his future appearance for the prosecutor's office. Consistent with Gilbert's desire to review the results and methods of the crime scene investigation, he next called Henry Dombrowski to the stand. Dombrowski had been employed by the Cleveland Police Department since 1942, and in 1954, he was a member of the Scientific Investigation Unit, SIU, which investigate crime scenes. He first went to the Shepherd crime scene on July 23, 1954, along with fellow SIU members. There was a Detective Rubel, Detective Pokin, and Dombrowski recalled that after taking a general tour of the home that day, he inspected specific areas of the house. Attorney Gilbert projected a series of crime scene photographs that show chalk circles. Dombrowski said that the circles denoted areas where the officers detected suspected blood spots. Based on this information and the report that his group prepared, Dombrowski acknowledged that there were drops from the basement to the kitchen, from the kitchen to the second floor, from the stairwell landing to the second floor hallway in the living room, on the porch floor, on the red leather chair in the den, on the room floor, in the daybed area, on the basement floor. Gilbert referred to this evidence as a blood trail. When Attorney Gilbert then asked if Dombrowski had removed a piece of wood with a blood stain on for laboratory testing, Dombrowski replied that he had. Had he used modeling clay to get a tool impression from a door in the basement? Dombrowski said he had noted what seemed to be an impression made by a tool that was used to get the door open. He said that he did not recall collecting this impression and that he had not testified about it either of the other 2 trials. In public interviews, Attorney Gilbert had referred to this finding as a significant new discovery. On cross-examination, Mason quickly tried to minimize the significance of the tool mark. Utilizing pictures of the basement, Dubrovsky confirmed that it was an inside door that led to a crawl space under the house and that the mark was made on the inside basement side of the door. In response to a question by Mason, Dubrovsky said that there was no evidence of forced entry. Turning to the SIU detectives' overall investigation of the Shepherd home, Dubrovsky told Prosecutor Mason that they invested a great deal of time inspecting the home. They were there on July 23rd, 26th, 27th, again on August 2nd and August 5th, and they conducted a thorough investigation. Prosecutor Mason turned his attention to the blood trail, asking Dubrovsky if he had been able to detect with his unaided eye many of the spots he had circled. Dubrovsky said no, saying that they had to use a portable spotlight and luminol spray that would illuminate blood traces. The detective noted that any product that had iron in it, such as Coca-Cola or tea, could provide a false reaction. He added that even if blood was detected, it would have to be tested to determine if it was human or animal blood. Mason pointed out that the Shepherds owned a female dog and that it was possible that the blood was from the dog. The first medical expert called by the Shepherd team was William Fallon Jr. Dr. Fallon was the director of the Division of Trauma Critical Care, Burns and Metro Life Flight at the Metro Health Medical Center in Cleveland. And he was also an associate professor of surgery at Case Western Reserve University and the author of numerous publications addressing issues of trauma care. Dr. Fallon was retained as an expert witness by the Shepherd team to review and analyze the medical records of Dr. Sam Shepherd. Unlike Officer Drankin and Detective Dubrovsky, this witness owed his entry into this case directly to the Shepherd team. This fact does not mean that he will not be objective and professional, but experts hired by a legal team tend to receive their information, direction, and perspective from attorneys who have a significant stake in the outcome of the case. So Dr. Fallon reviewed and interpreted the medical reports of the physicians who treated Dr. Sam Shepherd for the injuries he suffered the morning of July 4th. Based on this review, he addressed the nature, cause, and severity of the injuries. Reviewing the report written by a Dr. Carver, Dr. Fallon described the general physical condition of Dr. Sam Shepherd on his admission to Bayview Hospital that morning. Shepherd was described as being in some distress because of pain in the neck and as exhibiting some puffiness around the right eye. The rest of the physical examination was negative except for the mouth, which shows some upper front teeth that are loosened. Gilbert then handed Fallon another document, which he identified as an X-ray report for films that were obtained the 4th of July, 1954. The report is signed by G.C. Flick. This report contained a number of diagnostic tests, including sinus X-rays, a skull X-ray, 2 different views of the base of the skull, a lateral cervical spine film, open mouth film, rib film, and pelvis film. Fallon explained that these types of films would ordinarily be obtained consistent with the workup for an assault or motor vehicle crash. He proceeded to describe the findings of the report first in medical and then lay terms. The frontal sinus on the right side, Fallon said, pointing to an area just above the eyebrow, is generally filled with air, but in this case, it was filled with fluid, which would suggest blood in the sinus as a consequence of trauma. There was a lateral neck film that showed degenerative joint disease and a chip fracture, which could be produced by a blunt force striking the second cervical vertebrae. Gilbert walked up onto the witness stand so that Dr. Fallon could demonstrate the location of the fracture, and Fallon pointed to an area at the base of the neck. Attorney Gilbert introduced another report dated July 7, 1954, which documented a second series of sinus films, lumbar spine films, and the lateral cervical spine film. This reinspection, according to Fallon, showed no signs of the chip fracture. When Attorney Gilbert asked him to explain this important discrepancy, Fallon speculated that it could be the result of technique or the film. In response to Gilbert's question, Dr. Fallon said that the first film was more of a screening film. The second set of films were the more precise, definitive films, which led him to conclude that there probably was no fracture. Attorney Gilbert presented another consultation report July 4th, 1954 at 2:50 p.m. by a specialist, Dr. Clifford Foster. Dr. Fallon noted that it described marked swelling and bruising around the right eye, extending over the entire right side of the face, a contusion on the left side of the neck, and swelling below the base of the skull. Gilbert asks, so that bruising on the left side of the neck was objectively seen? And Fallon responded, that's correct. So Attorney Gilbert handed Fallon another report, which constituted a summary of the treatment provided to Dr. Sam Shepard during his stay at Bayview Hospital. The complaint section noted pains in the back of the neck, multiple contusions, bruises, and lacerations. Fallon said it recorded a history of severe beating, loss of consciousness, and exposure of 6 to 8 hours. The diagnosis listed a concussion to chipped teeth, mild shock, and multiple contusions, lacerations, and abrasions. It ruled out any basal skull fractures or fractures of the jaw and neck. The final diagnosis prior to discharge was cerebral concussion, brain contusion, cerebral edema, laceration of the right cheek inside the mouth, contusion of the spinal cord, dislocation of teeth, 2 chipped teeth, multiple bruises and abrasions. So next, Attorney Gilbert turned to a consultation reported on July 6, 1954 by Dr. C. Elkins, a neurosurgeon who evaluated Dr. Sam Shepard. Based on an examination and a review of the original x-rays, Dr. Elkins noted in his report that the pupils were equal, eyes normal, no facial weakness, but numbness of the ulnar nerve on the left side of the arm. Fallon said that the ulnar finding could be consistent with an injury to the central portion of the spinal cord. Elkins' local examination of the neck also disclosed tenderness and spasmodic contractions, which Fallon claimed could not be faked. At this time, a lumbar puncture had been performed to determine if there was a spinal cord injury. The test revealed no blood and was found negative. Gilbert then asked Dr. Fallon to evaluate Dr. Sam Shepard's injuries based on all this evidence. And Fallon responded that there were traumatic soft tissue injuries to the head, neck, and face that were sustained. There was a clear history of a concussion injury primarily affecting the brain. There is reasonable evidence to support the diagnosis of spinal cord contusion injury. And he concluded that these injuries were caused by a blunt force trauma. He concluded that these injuries were caused by that, and in an attempt to dramatize the conclusion of his expert, then Attorney Gilbert asked, "Do you have an opinion based on reasonable medical certainty whether the wounds suffered by Dr. Shepard were consistent with an assault upon him?" And Fallon responded, "They were." And then Gilbert said, "Do you have an opinion based on reasonable medical certainty whether the wounds suffered by Dr. Shepard was self-inflicted?" And Fallon responded, "They were not." So Prosecutor Mason listened to this carefully orchestrated exchange, did not necessarily disagree with many of its conclusions. He also believed that Sam Shepard had been assaulted and that the wounds had probably not been self-inflicted. No, the real issue was the source of the blows. There was no question that Marilyn had fought valiantly for her life. Mason was convinced that the murderer she repeatedly struck was Sam Shepard. His injuries were consistent with this scenario. In fact, the only part of the diagnosis that Prosecutor Mason would contest was whether Shepard really suffered a fracture to the neck. This type of injury would be least consistent with Marilyn's fight for survival. The other element of Dr. Fallon's testimony that intrigued Mason was how carefully the doctor had crafted his responses to inquiries about the spinal cord injury. He had not provided an unqualified affirmation. Instead, he said that there was no reasonable evidence to support this diagnosis. Prosecutor Mason knew how witnesses could qualify responses to provide an impression without directly answering the question. But Prosecutor Mason and the other prosecutors recognized that Dr. Fallon's testimony had, on balance, helped the plaintiff. So if it was essential that the flawed premises that form the basis for these evaluations be exposed. So in his cross-examination, Prosecutor Steve Deaver would try to show that the injuries suffered were consistent with domestic violence, and that he would also make sure the jury knew that not all of Shepard's medical examinations were shared with Dr. Fallon. So Prosecutor Deaver opened his questions by having Fallon confirm that his evaluations and conclusions were based entirely on medical charts provided by Bayview Hospital, and that he has spent a total of about 2 or 3 days in preparation for this trial. Deaver asked the doctor whether he ever looked through the testimony of the actual physicians as they presented their reports in the first and second trial of Dr. Sam Shepard. Fallon said that he had not because he did not believe it was pertinent to his work. Prosecutor Deaver said, "So you felt that reading of the testimony of the various physicians that treated Dr. Sam Shepard from July 4th to July 8th of 1954, their explanation and their detailed descriptions as far as what they observed, you didn't use that to arrive at your opinion here today?" Fallon responded, "No, sir, I did not." So Deaver persisted. "So you did not review the testimony and explanations of Dr. Gervais Flick, the osteopathic radiologist, Dr. Charles Elkins, the neurosurgeon, Dr. Richard Hexter, the general practitioner, Dr. Clifford Foster, Dr. Richard Cogg, the dentist, Dr. William Seltnick, the osteopathic surgeon, Dr. John Novotny, another dentist?" And Fallon acknowledged that he did not. So Deaver said, did you read the testimony of Dr. Sam Shepard himself as far as how he described the nature and severity of his injuries? Again, Dr. Fallon responded that he had not, this time explaining that he wanted primary rather than secondary data so that he deliberately stay away from it. In a quizzical tone, Prosecutor Deaver said, "Did you understand, first of all, the nature of the relationship that existed between Dr. Stephen Shepard, Dr. Richard Shepard, Dr. Richard Shepard Sr., and the patient in this particular case, Dr. Sam Shepard?" Deaver explained that they were family members, that Bayview Hospital was their family-owned hospital, and that Dr. Richard Shepard Sr. was the chief proprietor of the hospital. He then asked if Fallon knew who the attending physician was during the whole period of time. That Dr. Sam Shepard was a patient at Bayview Hospital. Fallon said that he did not. Prosecutor Deaver referred Fallon to the Bayview Hospital case summary record, which he had previously read from on his direct testimony with Attorney Gilbert, and noted that it had been signed by Dr. Stephen Shepard. Deaver then asked Dr. Fallon to review the X-ray report prepared by Dr. Flick on July 4th, 1954, and to decipher the notations relative to the lateral neck X-ray. Fallon described the presence of a chip fracture of the second vertebrae, referred to as the C2, and bridging at C5 and C6, indicative of arthritis. He indicated that a chip fracture of the C2 is unusual, saying that he had never seen one in his 20 years of reviewing X-rays, and that this injury was not really that severe. Deaver provided a report of July 7th, 1954, which documented a second X-ray of the same lateral neck area. The same radiologist, Dr. Flick, based on this X-ray, did not detect the chip fracture or arthritis. Regarding these dramatic changes, Deaver asked Fallon, "So you cannot exclude the possibility that the X-ray were switched or substituted in this particular course of treatment of Dr. Sam Shepard, can you?" And Fallon responded, "No, I cannot." Prosecutor Deaver continued poking holes in Fallon's presumptions, asking, "Did you consider in your evaluation whether or not you were looking at the same X-rays of the same neck?" And Fallon said, "No, I did not." So satisfied that he had established that Sam Shepard had not suffered a chip fracture and that something unusual had happened at Bayview Hospital in regard to these X-rays, Prosecutor Deaver asked a series of questions meant to challenge the completeness of the medical record provided to Dr. Fallon. He said, "Were you aware that sometime in the afternoon, around 3 in the afternoon, that a Dr. Richard Hester was brought in who was not associated or affiliated with Bayview Hospital, I believe at the request of Dr. Samuel Gerbert at the Cuyahoga County Coroner?" Dr. Fallon responded, "No, sir, I did not. If I didn't document it in the medical record, I didn't review anything about his physical examination." In response to further questioning, Fallon stated that to his knowledge, there was nothing in the medical record about this examination. At this point in the cross-examination, the doctor seemed uneasy, stroking his beard, glancing around the courtroom. Prosecutor Deaver persisted in his endeavor to demonstrate the glaring omissions in the medical records that Fallon had reviewed. He asked him, "Were you aware that Dr. Charles Elkins was called to examine Dr. Sam Shepard. Fallon recognized this name, but admitted that he was not aware of any notations in the medical record documenting that during his neurological examination, Elkins did not find any evidence of a fracture of the C2 vertebrae. Deaver then wanted to reaffirm for the jurors that there was no chip fracture, so he asked Fallon in a manner that mimicked Terry Gilbert. He said, "For the ladies and gentlemen of the jury, you can clearly state to a reasonable degree of medical certainty that we don't have a C2 chip fracture. Is that correct?" And Fallon acknowledged that's correct. Prosecutor Deaver then addressed the claims that Dr. Sam Shepard may have received a contusion or bruise to the spinal cord. He noted that the lumbar puncture did not provide any evidence of a bruised spine, and numerous examinations of Shepard's eyes concluded that they appear normal. In regard to the reflex test that Fallon reviewed for his direct examination, the doctor now admitted that these tests are a more subtle indicator of injury for which he would consult a neurosurgeon for an interpretation. Prosecutor Deaver, somewhat surprised by Dr. Fallon's deference to neurosurgeons, seized the opportunity to ask if he knew Dr. Robert White, a Cleveland neurosurgeon. Fallon responded that he knew Dr. White and that he was a very good neurosurgeon. And Deaver then asked if there was any evidence in the medical record of a loss of consciousness due to choking. Fallon said that the loss of consciousness from this cause would generally result in a pattern of injuries that were not detected in Sam Shepard. Therefore, Dr. Fallon concluded that there was no evidence in the medical record of loss of consciousness due to choking. Finally, Prosecutor Deaver wanted to introduce the theory that the injuries suffered by Dr. Sam Shepard may have been the result of defensive blows struck by Marilyn Shepard. So he asked, "Do you see cases involving domestic violence?" Fallon said that he does. And Deaver continued, "The evidence that you have in this particular case, as far as the source of injuries to Dr. Sam Shepard, you cannot tell us how those injuries came to pass as far as who the assailant is. Is that correct? Then, and you have, in the years that you have been practicing medicine, doctor, have seen many times where a female victim has been brought to the emergency room with severe injuries, and the husband or boyfriend has been treated with less severe injuries." With Dr. Fallon nodding his head in the affirmative and answering "that's correct" to this series of questions, Prosecutor Steve Deaver thanked the doctor for his participation. Judge Suster dismissed the juror for lunch. The day's final witness was Dr. Harry Hall, a physician who had staff privileges at Bayview Hospital from the 1950s to the 1970s. The only significant element of his testimony was that when he saw Sam 2 days after the murder in the radiological suite, Sam's face was swollen and that he had seen Sam's x-rays, which revealed a complete fracture of the fourth cervical vertebrae. Mason and Deaver were surprised that the Shepard team would even present this witness, given that his analysis would seem to contradict that of Dr. Fallon. On cross-examination, Dr. Hall reaffirmed that the fracture he observed was of the C4 or possibly the C3, but there was definitely not a chip fracture of the C2 or bridging at the C5 and C6. He maintained that those findings would be hard to miss. When presented with Dr. Flick's findings to the contrary, he stated in a puzzled tone that he now wondered about Dr. Flick's findings. Hall also acknowledged that Dr. Stephen Shepard would not allow anyone to visit Sam Shepard, and that Stephen was abrasive with the authorities. And Prosecutor Mason believed that Dr. Hall's testimony only seemed to cast more doubt on the integrity of Sam Shepard's x-rays. So on the morning of February 18th, attorney Terry Gilbert started the day by calling Eileen Hughes Bennett. She was the x-ray technician who actually took the films of Sam Shepard. Gilbert seemed intent on trying to document Dr. Shepard's physical condition after he was admitted to Bayview Hospital. Mrs. Hughes Bennett entered the courtroom in a wheelchair, and she looked very frail. She told the court that she was 85 years old. In response to questioning from Attorney Gilbert, she testified that she had received an emergency phone call, probably from the switchboard on the morning of July 4th, 1954, asking her to take x-rays of Dr. Sam Shepard. She remembered Shepard as appearing to be badly injured, with blood on his face, a welt on the back of his neck, blood on his teeth, and bruises. She also recalled how he was moaning and stated that none of the other Shepards were in the x-ray room when she performed her task. Mason knew that her testimony did not correspond to the responses she gave in her deposition 4 weeks earlier. In cross-examination, Prosecutor Mason reminded Mrs. Hughes Bennett that she had previously indicated that Dr. Stephen Shepard had called her at home and requested she come to the hospital, and that he had given her the instructions for the x-rays. Eileen said that she did see Dr. Stephen Shepard and Dr. Richard Shepard that day, but was not sure when. Prosecutor Mason read her deposition testimony to see if it would refresh her memory, telling her that she stated she saw Dr. Stephen Shepard in the x-ray room, and he told me what x-rays he wanted of Sam, end quote. She appeared genuinely confused and exclaimed that she believed this to be accurate when she said it. When Prosecutor Mason then asked Mrs. Hughes Bennett if the x-rays she took were ever left unattended, she said yes. The next witness called by Attorney Gilbert was James Redinger, who had known Sam and Marilyn Shepard when he was a teenage neighbor of theirs in Bay Village. He recalled that he and a few other teenagers were often invited to the Shepard home to play basketball and water ski. Redinger characterized the relationship between Marilyn and Sam as being loving and respectful. Turning to the events of July 4th, 1954, he recalled getting a call from a friend telling him that Marilyn had been murdered. He described for the court how he rode his bicycle to their home, where he saw people, milling about, going in and out of the house. Seeing that the house was not roped off, he said he and another friend entered the home, walked down the hallway into the living room, and sat in chairs. Someone sometime later said, "Let's get the kids out of the house." He remembered, and he and his friends then went outside, where they were later enlisted by the police to search the backyard and the tall, thick underbrush. He told the jury that his teenage friend was Larry Hook, the son of the mayor, and he discovered a green bag on the steep bank to the left of the stairs, and that he remembered Hook holding the bag and then dumping its contents, watch, ring, keys, into either his own hand or my hand. Redinger said that they noticed a few blood droplets on the crystal of the watch. The boys then put the contents back into the bag and gave it to a detective. When asked by Gilbert to describe the scene, Redinger said that a large number of people stood around the Shepard house on the sidewalk and across the street. On cross-examination by Dean Boland, Redinger said that he did not recall seeing any blood in the study or living room. He described the area where the bag was found as a very steep incline that was difficult to traverse and that there were no paths through the brush. He also recalled touching the watch only on its edges. When asked to provide a more precise idea of how many people were at the Shepherd home, he answered that there were more than 10 people outside and 5 inside the house. Finally, Bolin asked if he was ever in Marilyn's bedroom, and Redinger responded that he had been in that room and pointed to a picture of the room, said that he recalled a lamp being in the corner by the window. The final testimony of the day was provided by a witness from the 1966 trial. Because Patrick Guerreau was deceased, Judge Suster allowed the Shepherd team to read into the record his testimony from the transcript of the 1966 trial. The judge told the jury to evaluate this testimony in the same way they would evaluate any other testimony, except for observations about demeanor. He explained that Terry Gilbert would assume the role of the questioning prosecuting attorney, while his associate George Carr would read the answers of Patrick Guerreau. Gilbert and Carr assumed the roles and read the direct examination of Guerreau. Carr sat in the witness stand while Gilbert took his familiar position behind the attorney's podium. From the Gilbert-Carr reenactment, the jury learned that on July 4th, 1954, Patrick Guerreau was a detective with the Cleveland Police Department Homicide Unit, that he and his partner, Robert Schottky, arrived at the Shepherd home between 8:45 and 9 a.m., where they joined Dr. Gilbert, Bay Village police officers, Jay Hubbard, Fred Dreckham, Detective Michael Gabrowski. At about 11 a.m., Guerreau and his partner drove to Bayview Hospital, where they visited Dr. Sam Shepherd for about 25 minutes. They returned to the Shepherd home at around 1 p.m. and searched the house and the grounds. Guerreau recalled that someone from the county morgue was in the house and that there were several Boy Scouts searching the brush. A young fellow he found later was Larry Hook. He testified that he called out saying he found something and brought him a green bag. Guerreau described looking inside and seeing jewelry, making sure not to touch it. He saw a watch which appeared to have blood on it, noted that the hands were stopped at 4:15. He took the bag inside the house and gave it to Dr. Gerbert, who spread the jewelry out on the table in the dining room. He described how Gerber then wrapped the items in some Kleenex or tissue paper and put them in a box and placed the box in the green bag. At 3:30 p.m., Guerreau went back to Bayview Hospital with the bag and the box, spoke to Dr. Sam Shepherd again for about 30 minutes. Guerreau was then asked if he had gone into the basement of the Shepherd home. He said that he had, and while there, he had discovered a laundry basket that contained 3 t-shirts size 38-40. Following the stage direct examination by the prosecution of Patrick Guerreau, Gilbert assumed the role of F. Lee Bailey in order to submit the testimony of Guerreau on cross-examination by the defense. This portion of the testimony from the 1966 trial was more vital to Gilbert's attempt to expose the ineptitude of the crime scene investigation in 1954. In a rigorous cross-examination of Guerreau, Bailey asked about the detectives' handling of the green bag and its contents, specifically about whether the items had at any time been checked for fingerprints. Guerreau said to his knowledge they had not. Bailey moved on to pose a series of questions about the condition of the watch, ring, and keychain. And so he asked, do you say these objects are in the same condition that they were in when you found them or when they were brought to your attention in July of 1954? The detective examined each item, said that the watchband was not broken when he found it, and that he had never before noticed the crack in the onyx setting of the ring. Bailey asked whether he had examined the clothes Sam Shepard was wearing that morning with the hooks around him. And when Garreau said that he had, Bailey queried, "Do you have in mind, from your recollection of the investigation of this case, Mr. Garreau, any explanation for the rip in the pocket?" And Garreau said he did not. Additional testimony was read about the extent of the search of the Shepard grounds and Lake Erie for a possible murder weapon, and Garreau also said that he did not examine Dr. Shepard for injuries or ask how he got them. And at the conclusion of this legal theory, Judge Suster dismissed the jury for the weekend. So on Monday, February 21st, Sam Reese Shepard took the witness stand for the entire day. His testimony did not seem pivotal to the resolution of the Marilyn Shepard's murder. He was only 7 years old on the fateful day, and by all accounts, he had slept through the night. However, many of the statements Sam Reese Shepard would make this day would have profound implications for the case in a social as well as a legal context. Sam Reese Shepard testified that he was currently a dental hygienist residing in Oakland, California. He had attended Boston University for 3 years before completing an associate degree at Northeastern University. As Gilbert displayed a series of photographs of his family, Sam Reese recalled the loving environment provided by his mother and father and described his home on Lake Erie, saying that as a child, he lived an idyllic upper-middle-class existence. He recounted his memories of July 3rd and 4th. His mother put him to bed the night of July 3rd. They say a prayer. He went to bed. He slept through the night undisturbed. His next memory was of being awakened by his Uncle Richard and Mrs. Hook, both of whom were very upset. He remembered being whisked out of the house through a small crowd and having flashbulbs going off in his face. His Uncle Richard and Aunt Dorothy took him into their house before he went on to live permanently with his Uncle Steve and Aunt Betty. His only specific memory of the 1954 trial was of being harassed by the media. After his father's conviction, he remembered visiting him in prison about once a month, and they corresponded regularly. During the 10 years his father was in prison, he said his dad's demeanor and personality began to change. Sam Reese Shepard recalled how he rejoiced when the U.S. Supreme Court agreed to accept his father's case and when they granted a new trial. He had strong memories of the 1966 trial, at which he testified as a character witness. He remembered celebrating his father's acquittal at a party at Boston University. After regaining his freedom, his father attempted to practice medicine again. Sam Reese Shepard testified, but any time he touched anyone who thought he was a wife killer, he was sued. And very soon, his livelihood was destroyed. Dr. Sam Shepard then moved to Columbus, became a professional wrestler, using the name Killer Shepard, which Sam Reese referred to as gallows humor. He attributed his father's early death in 1970 to a poor prison diet that damaged his liver. Sam Reese stated that between 1970 and 1989, he lived primarily in the Boston-Cambridge area, avoiding the case and the public spotlight. All this change, he said, as a result of his public advocacy against the death penalty and for prison reform. He was aware that his public speaking might rekindle interest in the unsolved murder of his mother, and was not surprised when a number of people contacted him wanting to provide information about the case. At about this time, his father's second wife, Ariane Tebejohans, gave him a number of boxes containing his father's letters, envelopes with exhibit numbers, and one box with bloody bedsheets, a bloodied quilt, and a bloodied pillowcase. He discarded the pillowcase and sheets but kept nearly everything else. In response to Gilbert's questioning, Sam Reese explained how he came to be in contact with Richard Eberlin. He told the court that a number of individuals, including an alleged investigator claiming to want to solve the Shepard murder case, told him that Eberlin was possibly the murderer. He then corresponded with Richard Eberlin, and based on their exchanges, found Eberlin to be a disturbed man who had a suspicious amount of knowledge about the facts of this case. And eventually, Sam Reese Shepard met Cynthia Cooper, a journalist and author, who agreed to take over the correspondence with Eberlin. Shepard's relationship with Cooper evolved in a co-authorship of a book detailing the search for Marilyn Shepard's murderer called Mockery of Justice. And it was published in 1995 and made into a television movie entitled My Father's Shadow. And the movie was filmed in 1998. To bring this chronology to a dramatic conclusion, Attorney Gilbert gave Sam Reese an opportunity to explain his motivation in filing the suit. And he said, quote, "Some people say that you should get a life and put this behind you. It's 45 years. Your father was found not guilty in 1966. He died at 46 years old. You're 52 now. Just put it behind you and let things stay the way they were. Why didn't you do that?" The prosecutor asked him. He's not the prosecutor, the attorney Gilbert asked him, and he said, Sam Reese asked, "Well, my mother was murdered. That offender has never been found. It's an unsolved murder case. My father's life was destroyed by the state of Ohio. Any man who would sweep that under the rug is not worth their salt, as far as I'm concerned." End quote. Frustrated by the sort of baseless accusation that questioned the integrity of the prosecutor's office, Prosecutor Mason saw this court appearance as the prosecutor's chance to expose these charges as pure fiction and to restore the integrity of the criminal justice system. Prosecutor Steve Deaver deliberately walked to the witness stand, faced Sam Reese Shepard, opened his cross-examination by extending his sympathy to Mr. Shepard for the loss of his mother. He then immediately started on his attack of Sam Reese's recollections. He said, "Did Sam Reese recall the testimony of Chief Fred Rankin, who stated that Chip was escorted from his home at about 6:30 a.m.? Are you saying that you specifically, for a fact, can indicate that there were newspaper photographers and newspaper people on the scene at 6:30 in the morning of July 4th, 1954? And Sam Reese said no, and began to twirl a pen nervously in his hand. And for the first time, Sam Reese Shepard's version of events would be challenged. To establish the identity and control of the evidence that Sam Reese had received from Ariane, Prosecutor Deaver asked a series of questions about the evidence in the boxes. Sam Reese testified that he donated the boxes to the Northeastern University archives and that he had only looked at most of these items very cursorily. He did not really inspect his father's wallet, the 21 envelopes of evidence, empty envelopes from the county coroner's office, a broken track trophy, a broken woman's bowling trophy, a letter from Dorothy Shepard to Marilyn Shepard, house keys, a diary kept by Dr. Shepard while in jail, blood vials, or an envelope marked kitchen ricer. He indicated that he didn't really read or inspect these articles because it was too painful. When Prosecutor Deaver told San Reese that he had traveled to Boston and Northeastern University to look at this material, but found that much of it was not there, San Reese said that Cynthia Cooper, James Neff, and the BBC, which produced a documentary on the case, did have access to these items, and that he thought Cynthia Cooper still had unauthorized possession of some of them. In a snide tone, he told Deaver that he knew that he had been at the archives and that the prosecutor's office had not paid the copy charges, and admonished him to look into that. So Prosecutor Deaver ignored that inappropriate comment, and he had San Reese Shepherd authenticate a number of items written by his father, including his will and letters. This corroboration of Dr. Sam Shepherd's handwriting would prove useful later when the prosecutors would present their case, by the way. Now, changing topics, Prosecutor Deaver asked, "Isn't it fair to say that always in your mind, always you believe your father didn't kill your mother?" And Sam Reese indignantly responded, "It is not a belief, it is a knowledge that I know through and through." When Deaver then asked whether he ever read his father's testimony, his father's statements to homicide investigators, or his father's statement to witnesses, Sam Reese responded, "No." Prosecutor Deaver asked in a surprised tone, "You never looked at the record from 1954 or 1966 as to what the state of the evidence was against your father?" Sam Reese Shepherd then tried to qualify his answer by essentially admitted that it was true. This was true. And then Prosecutor Deaver asked, "Did you ever sit down with your dad and ask your dad what happened that night?" Sam Reese responded curtly, "No need to, and I didn't." And so Prosecutor Deaver persisted. He said, Did your dad ever give you an explanation or offer to give you an explanation of what happened on July 4th, 1954? At this juncture of the questioning, Sam Reese Shepherd went off in an unexpected direction, and he said to Deaver, "My dad and I talked about the surrounding environment in terms of the marital agreements and associations which influenced the environment in which this tragedy happened." Prosecutor Deaver, somewhat surprised, his interest piqued, and he then asked, "What were those agreements that your dad told you of?" And Attorney Gilbert, sensing great peril in this line of questioning, jumped up and objected. To Prosecutor Deaver's relief, Judge Suster overruled the objection. Sam Reese stated matter-of-factly, essentially, that they had some problems. My dad was allowed to have a kind of an open marriage, while my mom worked out some personal sexual problems of her own. Sensing that this was an astonishing admission that would buttress the state's case, Prosecutor Deaver tried to develop this revelation further by asking questions about Dr. Sam Shepherd's extramarital affairs, allegations of Marilyn's adulterous affairs, and the meaning of an open marriage. But Judge Suster allowed none of them. Concealing his frustration, Prosecutor Deaver changed directions to dig into the financial aspects of the books and movie deals surrounding this case. He introduced several book and movie contracts, observing that for the movie rights, Sam Reese Shepherd had received $70,000 as an advance, and another $305,000 after the broadcast, plus clauses that provided for 5% of the gross profits and additional compensation for a rebroadcast. As Deaver continued his probe, Sam Reese became visibly irritated, and his responses were increasingly sarcastic. To Deaver's questions about his book contract, he responded that it would be helpful if Prosecutor Deaver looked into entertainment law. And as Deaver wrote some of the dollar figures on the poster board, Sam Reese blurted out, "That's not a correct figure." When Deaver discussed how the proceeds of the book and movie rights were to be distributed, he noted that AMSEC, a supposedly independent private investigative group recruited to provide information for the book, was to receive 5% of the proceeds and was to be mentioned in the book. Sam Reese said that AMSEC would receive 5% but rigorously denied that they would be mentioned. When Sam Reese demanded to see a document to refresh his memory, Deaver gave him a letter to Cynthia Cooper on AMSEC, letterhead entitled "Agreement Between Shepard, Cooper, and AMSEC," and asked him to read aloud a provision of the agreement, the compensation clause. It says, and quote, "They will pay AMSEC 5% of any income paid to them jointly or separately. That AMSEC will be credited in the text in the body of the work, and that an essential element of this agreement is that AMSEC be included in any publicity using the corporate name, and that Shepard and Cooper would include AMSEC in any publicity connected with the work," end quote. The contract with Northeastern University Press provided an advance of $21,000 and 10% of list price of the first 10,000 sold and 12% thereafter. Clearly, the Shepard case generated income and provided financial incentives for Sam Reese's collaborators and advisors. Karen Mann, his literary agent, Cynthia Cooper, his co-author, and AMSEC, if not for Sam Reese himself. Within this context, Prosecutor Deaver asked, Did there come a point in time that Karen Mann contacted you and Cynthia Cooper and said it would be a lot easier to get the book published if you could get the prosecutor to open the case again? And Sam paused and then stammered, "Not directly, but I think Miss Cooper mentioned that to me, possibly." Prosecutor Deaver then produced a letter addressed to Sam Reese Shepard from Cynthia Cooper, urging him to get the prosecutor's office to reopen the case. Deaver also pointed out that this lawsuit was filed on the very same day that Sam Reese's book was published. Sam Reese said this was a mere coincidence. Later on the testimony, Prosecutor Deaver exclaimed, "As you come to today on this journey, you're telling the ladies and gentlemen of the jury that you were not motivated in any part by any efforts to sell this book, to create royalties for your collaborators or yourself on the use of the book and the subsequent movie rights and all those deals. Is that correct?" And Sam, venting years of frustration, answered with a sense of righteous indignation. "We had to make a living in conjunction with the case that has been characterized as a massive, pervasive, prejudicial publicity by the United States Supreme Court of this land. And I recognize very early on, if we were going to talk about this case in the public domain, that it would be my job, in a way, to go out in the public domain and create, perhaps against the Cuyahoga County Prosecutor's Office, massive, pervasive, prejudicial publicity to counterbalance the historic wrong that took place against our family. During this harangue, whatever you want to call it, prosecutors Deaver and Mason stared at each other in amazement. Sam Reese Shepard had just admitted that he had been waging a public holy crusade for more than 40 years. Consistent with these statements and indictments, Deaver asked Sam Reese about his numerous public attacks and accusations. When Sam Reese admitted to having stated that the prosecutor's office suppressed and withheld evidence, Deaver took the opportunity to impeach significantly the integrity of the Shepard case. He proceeded briskly to ask Sam Reese about his public accusations that the prosecutors withheld evidence of forced entry into the Shepard home. When Sam Reese said that he didn't make the statements, Prosecutor Deaver asked, "This refers to the Dombrowski report to which he testified last week that there were tool marks or chisel marks on an inside doorway at the foot of your home's basement stairs." And Sam reluctantly admitted, "Oh yeah, it appears that we were incorrect about that point. My understanding is that it was over by the cellar door." In an effort to ensure that the jury understood Sam's admission, Prosecutor Deaver said, "Just to clarify for everyone, then the foot of that staircase at the basement stairs, that crawl space door that leads over to the chimney area of the house, does it not? There's no access to the outside from that crawl space door." And Sam answered, "Right, not to my knowledge. I thought that the chisel marks were over on the cellar door on the other side of the basement." So Deaver, allowing himself sarcasm, asked rhetorically, "So we can call that a red herring, could we not?" And Gilbert objected, and so Deaver withdrew the question. Prosecutor Mason could cite numerous other false statements that Sam Reese Shepard had made over the years, but he was pleased that Prosecutor Deaver chose not to refute each one. He believed the jury now comprehended the personal dynamics involved in this case, a recognition that was reflected in the body language of the attorneys in the courtroom. Prosecutor Mason was now leaning forward in his chair, beaming, and the attorney, Terry Gilbert, sat slumped back in his chair, a frown on his face. Sam Reese Shepard, fidgeting nervously on the witness stand, ended his testimony by claiming that members of the prosecutor's office had acted in a very unprofessional manner toward him and his mother's exhumation. Feeling confident and energized by the day's success, Prosecutor Mason did not anticipate that he would reach his emotional low that day. Ironically, the legal controversy that would involve him was unrelated to the trial testimony. At the conclusion of the first week of trial testimony on Friday, February 18, the litigants held a press conference. Mason was the first to assume the podium, and he fielded a series of questions about the witnesses who had appeared and the evidence introduced. Pursuant to the stern instructions issued by Judge Suster, Prosecutor Mason was careful in formulating his answers. When he was asked if he thought the Shepard family had tampered with or misrepresented the medical x-rays, he refused to give his impression, and with great restraint suggested that this type of evaluation was reserved for the jury. Another reporter, after some faint good-natured prodding by attorney Terry Gilbert, he asked Prosecutor Mason if there was a possibility of a settlement between the parties. Again, Mason responded vaguely, answering that he was a reasonable person, that he was always willing to talk. But a few questions later, and after he thought about the fact that the trial was now underway, in response to another question about the likelihood of settlement, Mason said, to be quite honest, we can say those words, settlement, but we are 2-3 weeks into this trial. To really be talking about a settlement now, I just don't think that's going to happen. Attorney Terry Gilbert followed Mason to the podium and described how pleased he was with the way the case was progressing. In response to questions about police procedures, Gilbert decried the crime scene contamination and the poor quality of police investigation. In response to an inquiry about settlement negotiations, he said that there was never a good faith effort to resolve this case, and even suggested that the citizens of Ohio should be concerned about the amount of taxpayer dollars that were being spent to defend this lawsuit. He claimed that he felt obliged to address the issue so that the media would understand the reality of the settlement negotiations. Consistent with this new approach, Sam Reese Shepherd and Terry Gilbert conducted a number of television interviews that weekend, assailing the prosecutor's office for not acting in good faith to settle the case. This continued effort to manipulate the media and public opinion appalled Prosecutor Mason and provoked him to respond rashly to the accusations. If Gilbert really wanted the media to know the nature and scope of the settlement demands, Mason would provide an objective insight. On Tuesday, February 22nd, in response to more questions about settlement, Mason informed the media of the settlement agreement proposed by Terry Gilbert, which requested $3.25 million to drop the lawsuit. So much for his concern about Ohio's taxpayers. But Prosecutor Mason found just as troubling as the money demands the plaintiff's stipulations that the state would acknowledge that as a direct result of that unconstitutional and unfair proceeding, Sam Shepherd was wrongfully incarcerated in Ohio prisons for 10 years, and that the state acknowledges that Sam Reese Shepherd and his attorney, along with the assistance of investigators and forensic specialists, have in good faith endeavored to solve the murder of Marilyn Shepherd since 1990, have shared their findings and opinions with the Cuyahoga County Prosecutor's Office. They are to be commended for their efforts in bringing evidence forward and for raising awareness of various issues in this case. Prosecutor Mason did not see how the monetary demands presented, which he thought were outrageous, and admissions required, constituted a good faith effort to settle the case. He thought the document read more like a complete capitulation rather than a serious settlement agreement. Mason was convinced of Dr. Sam Shepherd's guilt, and he would support only an unconditional withdrawal of the case with some consideration for reasonable expenses. Within hours of the release of this information, Attorney Gilbert was besieged by members of the media seeking his comments. He was enraged and demanded a sidebar before Judge Suster out of the presence of the jury. The judge agreed to the request, and Gilbert complained vigorously that Mason, contrary to the directives of the court, was making settlement negotiations public. He termed this disgraceful and claimed it could materially prejudice the judicial proceedings. To add to the gravity of the charge, Terry Gilbert cited the disciplinary rules section governing attorney behavior, which he claimed the Cuyahoga County prosecutor had violated. For a prosecutor, this was a very serious charge because these rules are promulgated by the Ohio Supreme Court to govern the conduct of all attorneys. A breach of these rules can result in significant disciplinary action. Gilbert said that he would not request a mistrial, but that he wanted a firm stand by the judge and admonishment of Mr. Mason for his behavior. Naively surprised by the furor created by his action, Mason stood firm in his belief that Gilbert's statements justify his disclosure and thought that the complaint leveled against him was the height of the hypocrisy. But he also now realized that the label of hypocrite paled in comparison to the charges being made against him. Desperately, he defended his reputation to the judge, noting that it was Gilbert who had provided untrue and misleading remarks to the media, and that the actions he himself had taken were efforts to correct what had been previously released to the press. The lawyers had clearly raised the ire of Judge Suster. He reminded the attorneys that just that morning he had informed them that this type of public disclosure should not be made. Prosecutor Steve Deaver, sensing the severity of the situation, jumped to Mason's defense, and also citing the disciplinary rules, noted that the rules do allow and provide for an attorney to refute false and misleading claims that are disseminated to the public. Deaver stressed that he did not think it was a fair characterization to say that there was any violation of the disciplinary rules or the canons of ethics. Judge Suster remained unmoved and maintained that the release of the figure was improper. He told Prosecutor Deaver that he had had enough of this and asked him to sit down. This turn of events stunned Prosecutor Mason and shattered his confidence. How could he had allowed himself to be outmaneuvered in a way that could compromise any tactical advantage he had earned? What if the judge declared a mistrial? Despite the settlement figures being cited in newspaper articles, Judge Suster questioned each juror and finally decided that they had not been tainted by this information. He called for the trial to resume the next day. Thank you for listening to The Murder Book. In the next episode, we will talk about the science, the suspects, and how the prosecution is going